Thanks for being here, and particularly thanks to those who have been in a number of these webinars and are getting a sense of the continuity among them. Administratively, I want to make sure that all of you have your speakers turned on so that you can hear the webinar. Do know that we are communicating during the webinar through text messaging, which is in the lower right-hand corner of the screen. When you all have questions for questions and answers, please click on the presenters so that all three of the presenters can see the question, and the host will not have to repeat it. Also, you will notice on the upper toolbar you have an option for feedback, but we're not going to use that option today. We're headed to the next slide. The entire series of these webinars is hosted by Florida's Technological Research and Development Authority, which is a special district created by the state of Florida over 20 years ago. To find out about TRDA's programs and history, please go to our website, www.trda.org. I'd like to introduce the presenters today, beginning with Carl Dakin. Carl is currently Executive Director of the Sullivan Chair for Free Enterprise at Regis University, which is located in Colorado. Carl is a consultant in entrepreneurial matters, particularly technology-based matters. He has been a technology law attorney, and he comes at this subject by way of both business and law. Carl is an author of a number of publications, including a book on technology transfer, which was one of the first that came out to provide many of us with guidance on how to go about technology transfer. Steve Thomas is with us today as a presenter. Steve is a partner in the law firm of Hayworth, Cheney, and Thomas. They are located in Melbourne, Florida, but also have offices in Orlando and Vero Beach. Steve, earlier in his career, was a design engineer for Harris Corporation and then a new product manager for Harris Corporation before getting a law degree and becoming a patent attorney who specializes in litigation but has a broad view of intellectual property as it benefits small businesses. Joe Allen is the founder of Joseph Allen and Associates, which is a consulting firm in public policy and in technology commercialization. Joe has been the director of the Office of Technology Commercialization for the U.S. Department of Commerce. He's the author of the Bayh-Dole Act, which empowered federally funded research from universities and federal labs and also prime contractors to actually transfer into the public sector by giving intellectual property rights to the entities doing the research work. Joe also helped to create the National Technology Transfer Act. He's been the past executive director of the National Technology Transfer Center. Some of you know me. I'm Bernie Zuzo. I work for TRDA, and I'm the manager of the SBIR Technology Commercialization Program. I'll be the moderator for you today. As we've done in the last webinar, I'd like to give you a sense of continuity over the first three. The first webinar dealt with an understanding of the technical development cycle. The second webinar addressed translating technology into business terms and translating company capability into the supply chain. The third webinar dealt with managing a technology or product pipeline. There's the pointer. The product development cycle is a key principle in all of these webinars. The product development cycle in the first webinar addressed technical development and the three phases in it. The first being technology development, product design, and manufacturing. The second webinar, we proceeded beyond these first three phases and got into product introduction and distribution and the supply chain. How technology ends up in products and distribution in the hands of customers or in the hands of other products, which then get advanced into systems. The first two webinars dealt with a single technology, single product, advancing from technology to product. The third webinar dealt with a series of technologies that are platforms for multiple end-use products. Consequently, a company then needs to manage this group, this series of products in a meaningful way. So we addressed pipeline management in the third webinar. Today we're going to address securing intellectual property. The presenters will clarify the intellectual property, the different types of intellectual property, and the differences among them. There will be two different perspectives presented on intellectual property. One will be a perspective from business, and the other will be a perspective from the law or the legal perspective. We'll also address the difference between obtaining intellectual property or having it and actually using it to protect your tangible and intangible assets. In the overview today, you can see we'll address a whole lot of information as we have in the prior ones. That information is tremendously condensed, so we've got a lot of ground to cover. But I would like for you to be aware that we will begin by taking a look at the various types of intellectual property, the reasons for securing it. Then Carl Dakin will address IP from a business perspective. Joe Allen will take a look at the federal legislation and its role in accelerating technology commercialization. Steve Thomas will take a look at intellectual property from a legal perspective. Both of these gentlemen want to offer tips on protecting intellectual property. I'll wrap it up and we'll go to questions and answers. So let's begin. We're going to first address the types of IP. Carl, I'd like to hand this off to you and ask you to take a look at the first four items. Perhaps tell us what their definitions are. Tell us the difference between registration and filing, the difference between state and federal activities. Thanks, buddy.
Hey, actually, I think I'm going to hand this off to Steve. If I recall correctly, Steve, you'll have the first four and I'll take the last four.
Okay. Carl, that sounds like what we agreed to, but I'm sure you could address those first four adequately. But we'll do that. Starting with patents, I think everybody has a pretty good understanding of that patents cover, inventions that have some kind of utility. There's also a kind of patent out there called a design patent. Bernie has asked us to talk about the difference between, filing and registration and so forth. Patent applications are filed at the federal level. There is no state jurisdiction over patents, and they are examined up at the federal level at the United States Patent and Trademark Office. That process takes a while, and hopefully what results from that process is an issued patent. We'll talk more about that. Copyright is a little different. Copyright covers the tangible expression of a thing, such as a novel, could be software code, photographs. It's the tangible expression that is the issue there. And copyright is not examined like patents. Rights and copyright spring into being from the minute you create the work. They can be registered, again, at the federal level. The federal government has exclusive jurisdiction over copyright, and that's registered at the Copyright Office. Trademarks identify a product or a service with a particular provider of that product or service. They obviously different than patents. We're all familiar with trademarks, things like Nike, Google, so forth. An incredibly powerful source of IP, and one that is underutilized, I would say, by most small businesses. Trademarks are, you file for the registration of a trademark, and the key with trademarks, unlike patents and copyright, is you have to show the federal government or the state government, there's two levels of trademark protection, but you have to show that you are actually using the mark in commerce, and your trademark is not going to issue as a registered mark until you actually provide some form of proof to the federal government if you're involved in interstate commerce, or the state governments if you're involved in just in-state commerce. And finally, we have trade secrets, which are exactly what they sound like. We're going to talk more about trade secrets later. This really is the know-how, the intelligence that you've developed that has value to you, that allows you to address a particular market in a certain way. And the idea with trade secrets is you have to keep them exactly that. You have to keep them secret. We'll talk more about that later.
Steve, for the first three, patents, copyrights, and trademarks, how do they get applied for if there's an application process or registered? How and who does that? And how are they defended? And who's responsible for finding out if there's an infringement and then defend them?
As far as patents go, Bernie, patents are applied for, again, at the federal level. Typically speaking, a patent attorney is going to prepare a custom generated patent application. There are very specific rules for that. As far as who's going to police that, it's up to the owner of the patent to come up with a method for understanding if there's somebody out there in the marketplace who's infringing. That service actually can be hired out. There are firms that specialize in enforcing patents. That can be done internally if it's a large enough organization. Typically, it's the patent owner who has a pretty strong knowledge of his own market, but that's how that works. Patent enforcement itself is actually done in the federal courts. Again, the federal courts have exclusive jurisdiction over patents. Copyright, again, is different. Copyright is really more of a form application that you just simply file with the Copyright Office. Your copyright registration, generally speaking, will issue as a matter of course. There's really no examination other than they just look at the registration form to make sure there's no anomalies with it. And copyright enforcement is essentially the same as patent enforcement. Again, it's up to the owner. In this country, there's no federal agency or entity that is responsible for policing IP. It's up to the IP owner to do that. And again, copyright litigation for infringement is specifically and exclusively federal jurisdiction. It's brought in the federal courts. Trademarks, registrations for application of a trademark, made again either at the federal or state level, depending on if you are engaged in interstate commerce or not. The Constitution does not give the federal government jurisdiction over in-state commerce, but it does over interstate commerce, and that's why you have the two levels there. Trademark applications are examined really for two things. One, to see if anybody else is out there within the jurisdiction using the mark. And the other thing they're looking for is, are you actually engaged in commerce in the jurisdiction with the mark? Those are the two things. And again, as far as enforcement goes, it's up to the trademark owner. Trade secrets, there is no registration. Trade secrets, you keep secret. You lock it away, and you protect it pretty much at all costs. The great example of that would be the formula for Coca-Cola. It's been 100 years, and nobody's figured it out to this day. They keep that locked away. So.
Steve, thank you very much. Yes, and thanks for that insight. Carl, you challenged with whether a contract is intellectual property.
Yes, contracts provide an interesting addition to your intellectual property rights. Unlike patent, copyright, trade secret, and trademarks, which apply to everybody anywhere because they're based upon federal or state law, contracts IP only applies when you have a relationship with another company or organization and you have a contract in place. What's interesting about contract IP is that once you're negotiating with somebody to enter into a contract, you can put anything into that agreement that you want to put to control and protect your assets, your innovations, that both sides will agree upon. So there really are no limits upon what you can do within the contract if everybody agrees. And it gives you an opportunity to custom fit what you're doing with that person and be very descriptive and highly detailed, where sometimes when you're working with the more common forms of IP, it seems like it's a one-size-fits-all. Then when you go to the goodwill, this is another form of value that follows a business, where if you've been in business for a while, there's an expectation that you'll continue in business and make ongoing sales. So if somebody's looking to acquire your business, they're expecting that the customers will follow and that there will be value in the business because you'll continue to make those kinds of sales. So it's a form of reputation or expectation that is associated with your business, and it's something that, again, requires good management in order to optimize the value. So if you reach a point where you decide that you want to sell your business or somebody makes you an offer, you're going to get the best price possible for your business at that time. The next item on the list is customers list and market studies. And again, this presents an interesting way of looking at what might be considered intellectual property, because if you have certain types of data, certain types of research information, certain government agencies or laws will recognize that that is yours and not somebody else's. And even though it might also be protected by another type of intellectual property right, what's important there is if a government agency takes the position that this is yours and not someone else's, then your competition cannot use your data to help themselves into the marketplace to compete with you. And they have to go back and start over and expend the same amount of time, energy, and money that you did in order to create this particular type of information. So it's kind of an indirect form of intellectual property right, but it serves the same purpose of acting as a barrier to your competition. And the last one on the list is branding. And this is similar in some ways to goodwill. I sometimes call it a reputation intellectual property. Because it is the likelihood that somebody will buy a particular product or service because of an association. It's very common in the celebrity business for somebody to endorse a particular product. My daughter works at Ultra, which is a cosmetic store where Justin Bieber just released a new fragrance for women, and with a full life-size image in the store. Nobody ordinarily would have bought that fragrance except for the fact that it's endorsed by Justin Bieber, and therefore it is his brand that is associated with the fragrance, and that gives value to that particular product. So on occasion you may find yourself where, one, you want to protect your brand, that is who you are, what your company stands for, whether that's integrity or quality or some other positive value. Or it may be simply that there is a certain level of innovativeness that is associated with who you are, and you would like for that to carry to other products that you may either create or that you may buy from someone else. So another form of intellectual property, something that definitely you should consider when forming your strategy to make sure that you're getting the best form of protection for your business and the best competitive advantage.
Thank you, Steve. Thank you, Carl. What I would like for the audience to be aware of is that in prior webinars we took a particular topic like technology, and we advanced it into an understanding for product development and manufacturing design. We also took technology and we translated it into business terms, in both cases extending our initial understanding of the subject into a later stage understanding or a business understanding. Here today, what we are doing is taking a legal aspect of intellectual property and we're extending it into business. We're working to show how intellectual property is a tool for growing businesses. And you can see the way this list of IP topics are broken up, that there's considerable impact on the business itself. It's not just a patent on the wall or an icon on a piece of paper. It has an impact on the growth of the company. Reasons for securing IP. Carl, you want to tackle this one?
Sure. The first item on the list for a justification to create, hold, and protect your intellectual property is that it is a way of protecting intangible assets in your company. And as we were preparing for the program today, we were struggling with the usual difficulties of talking about this very complex subject. And we kind of decided that we're going to point out the benefits and the risk as they come along and make you aware of them. But we won't be able necessarily to dive into the deep details where it may be hard to follow and hard to explain in the short amount of time we have. An intangible asset is one of these difficult subjects, because if you start a business and you put your heart and your soul into it, the blood, sweat, and tears, and you have an epiphany, a creative moment where you discover how to solve a particular problem with a new solution that may become later, after great development, may become a new product or service, all that effort, all that creativity is an asset of yours. And it's very difficult to protect that in the classical sense of locking it in a safety deposit box. And so the law has created these forms of rights called intellectual property, which cause people to recognize your effort and allow you to point to them and say, those are mine, you cannot use those unless I give you permission. And so the first point of intellectual property is to think about all these different things that you've done and say, this allows me to control those to determine who gets to use this particular asset. And that kind of sets up the second item, which is on this list, which is why. If I've created something new, why do I care if somebody else might want to do the same thing that I've already done, who may want to pick up all the hard work that I've done rather than to do it themselves and essentially mimic or copy what I've been doing and jump into the market with a product or service that looks just like mine, or might even try to go so far as to use my name on my innovation and claim it as their own. And the purpose of intellectual property from a business perspective is to prevent this type of misuse of using what you've worked so hard for without you getting appropriate credit or control over that ability, and that's to stop or halt or slow down your competition.
Carl,
so if you
Carl, excuse me, if you don't mind, I'm going to jump in here for a minute. And I know you're going to address competitive advantage in a couple of these future slides. I know that adding value and retaining the value of an asset we're going to also address. And what we're not going to address, so you guys might want to address it now, is avoiding potential liability and letting the folks know that there's such a thing as IP insurance. So I'm going to open that up for you two to briefly address. And enhancing company and product identity, we've been addressing it, and we're going to continue to address it. So if you two would be kind enough to tackle the liability and the insurance issue very briefly.
Yeah, with regard to potential liability, the intellectual property rights are intended to help you protect your asset, but they're also there to protect the assets, the innovation of other people. And it's very common during the course of engaging in business, particularly in doing research where you're involved with other people, that there's a possibility that your innovation may be mixed with somebody else's. And so by working to protect your intellectual property, you are also creating a defense against a claim by somebody else that possibly you misused their innovation, or that they claim something that you made was theirs. And so the whole aspect of having an intellectual property program not only helps you get into the market, but it also serves as a shield or a defense against claims that might come from other people. In that regard, one of the options that you may have is to acquire insurance. Go to an insurance company similar to getting comprehensive or general liability insurance, but in this case, getting insurance that protects you against claims that you infringed somebody else's intellectual property. This can be a very valuable defense to have in your pocket, particularly where you're working in an area that's very fast-moving, and it's difficult to tell with any degree of certainty who's doing what and who's leading the game at the current time.
Thank you, Carl. I'm going to get us to the next slide, which is your slide, this matrix on viewing IP and its business issues.
Thanks, Bernie. As an attorney and a business person, having been an attorney first and now wearing the business hat, which is kind of a reverse from Steve, it's an interesting change of mindset as you look at intellectual property issues. As an attorney, I always preferred to have as many intellectual property rights as possible. I did not give, I will say, as much consideration for how strong they were relative to what help they were. It felt good to have a double fistful of rights in my hands. As you go into the business mindset, you start looking at other issues, sometimes which unfortunately will trump your desire to have more intellectual property rights, and those we're going to talk about here a little bit. But as we look at this particular chart, there are three sections to it. On the far end on the left, we have assets. The blue columns are different types of intellectual property rights. And then on the right are a number of important business issues which will impact your strategy in terms of determining if you want to pursue and gain an intellectual property right, or how you're going to manage it and maintain it over a period of time. There isn't enough time to go through everything here, but I will just make an observation on the left in the assets. A lot of times people think of a widget or an invention as being the only thing that's protected by intellectual property. And the observation I want to make is almost everything in your business will have some element of intellectual property in it if you've invested any time or energy at all into making it or maintaining it. So who you know can be a trade secret. The data that you collected that showed that this particular path was not productive is valuable, even though it didn't work, but it's valuable because you know not to go there again. And so as you're going through your business, the first thing as a business person is to go back and look at everything in your shop and ask yourself, how did this come into being? Is there something I did that I learned along the way that is valuable to me in my business? And I need to think about that as a potential subject or an asset in an intellectual property standing. Then as we go into the types of IP, the thing that is good to note here is that there may be more than one type of intellectual property that you can use to protect a particular type of asset. Sometimes there's only one way to do it, but in some cases you may start with a trade secret at the time that you originally start your work, and later you'll decide that it is better to protect that as a patent. And so upon registration and publication of that patent, the trade secret will disappear, and you will protect that asset only from that point forward with the patent. So as you look at intellectual property rights, they will come into play, they may disappear having done their purpose, or you may find that you can stack them on top of each other to get better protection. Then going to the right side of the graph, there are four primary issues that I'm just going to talk about briefly. Again, the first one has to do with accounting treatment. When you invest into intellectual property rights, either by engaging in research that results in a patentable invention or in using a name in the marketplace that later becomes a trademark, you have to determine for IRS purposes whether you are going to, how you're going to handle that on your books and records. And from an accounting standpoint, it's almost invariably going to be your cost. If you spend $1, that's what it is. Even if it might be worth more than that, which we get into in valuation, from an accounting standpoint, you're going to talk about cost. Now, at that point, there's still some other issues that may come up, which is, are you going to expense all that cost in the current accounting year, or are you going to capitalize this intellectual property and charge it off as an expense over a period of years that matches up with the revenue that you generate from that particular expense? This is a question that you need to sit down with your CPA, your accountant, and determine what's best for your overall strategy. As we move to the issue of tax treatment, this is how you treat the revenue that is directly attributable to your intellectual property rights. In most cases, you're going to find situations where you're selling a product or service that is based upon your intellectual property, and the sales revenue is ordinary income that goes in the usual places on your tax form. But in certain cases, you may be able to bundle and sell the intellectual property rights as a group, and in that case it may qualify for capital gains treatment, which can be taxed at a lower tax rate. A third issue that is important are tax credits. If you are doing research from year to year and you are increasing the amount of research that you're doing from year to year, the difference from this year to the next may qualify for a tax credit, a direct offset against your income that you're generating. All questions to bring up with your accountant, and like most things dealing with intellectual property, they need to be dealt with regularly, periodically. They should be dealt with before you start, not after you're done, because you may have found by the time you get done you've missed options that you otherwise would have had and opportunities that you should have pursued. In looking at the valuation of a technology, you can use your book cost, which is what you've invested into an IP, or you might want to use a market value. And market value of a technology tends to be a going forward or projection forward in time that represents the net benefit that you get from owning that particular technology. And we'll talk about that in more detail a little bit later this morning. The last thing is in your commercial transactions is how do you structure the intellectual property relative to the person who's going to receive it. Do they merely buy a product, which allows them to use the product, or are they buying the right to manufacture and resell a product? Can they take a product and change it a lot? There's all kinds of options in here that range between a sale, which is a complete transfer of all rights, and a license or a sale of a product in which a intellectual property right is embedded. So There's across the bottom of the screen, there are a number of different descriptions about different types of relationships, different structures, and these are the kinds of topics that we're going to get into in the next webinar down the road. But for the moment, just take a look at a couple of the items on this page, and you can see where proprietary information might be protected as a trade secret, but that information actually might become part of an innovation which is protected by a patent. And as you go across the page, this change between trade secret and patent doesn't really impact it too much, except that it may change your tax treatment. So every item of intellectual property that you have in your possession, in your portfolio, your collection of intellectual property rights, needs to be individually analyzed and understood in how it contributes to your business and how you're going to manage and invest in that particular IP.
Carl, thank you. This information is profound. It's very complicated, profound. Thank you for the clarity that you work to provide here. I would like for us to, I'd like for you, Carl, and Steve, if you want to add something to this next slide. I'd like to address it, but because we're running way behind time, I'm going to jump over a handful of next slides and get to Joe Allen's contribution. But before that, Carl, would you kick off your address for adding value from IP?
Yeah, I'm going to just work with a couple here. One is the patent. This is sometimes referred to as the king of intellectual property rights because it allows you to be the sole person who is bringing a particular innovation to market. And that's important because it means that you can sell the product and set whatever price you want to without someone coming in and cutting the price out from underneath of you offering the same product. That higher profit margin is critical to recapturing your investment in creating innovation. It's important to have the money to go forward at high growth to bring that product into the market. And so having a patent is a very, very valuable proposition in terms of intellectual property rights. In terms of trade secrets, which may be the way you start to protect something before you switch to patents, it's more of a head start advantage. Think of yourself in a foot race where you take off running and you're all the way around the track one time, and because you're putting this time and energy into your innovation, and now somebody enters the market behind you. Well, if the trade secret forces them to follow you around the track, they're going to have to run fast to catch up with you. They still may do that, but they have to stay on the track, where without a trade secret, if they find out what you're doing and learn everything that you know, they can cut across the field and catch up with you immediately, and all the time and energy you've spent on getting to this point is basically been lost. So the value of IP is to stay ahead of your competition and be as far ahead as you can and to slow them down as much as you can.
Sorry, my microphone was turned off. Apologize for that. Steve, would you like to add anything to this slide?
Well, no, Bernie, I would always love to talk. I think Carl's done a good job. The one thing I will mention, though, and I know we're behind time here, but when we talk about patents being the king of IP and a monopoly, it's good to keep in mind that patents are a monopoly, but they're a limited monopoly in that they do expire after a certain amount of time. And so the question is, when you're considering keeping something trade secret versus seeking patent protection on it, you have to consider the market life cycle and how that plays into the the life cycle of a patent. Because once that patent expires, unless you have conducted some continuing improvement and filed some continuing applications and have additional patent protection, you're going to lose patent protection. Generally speaking, about 17 years from the date those patent issues. Now, in today's markets, that may far exceed the actual market life cycle, so that may not be an issue. But we still have markets that have much longer lifespans than that. And so that's just something to keep in mind.
Steve, thank you. I'm going to quickly move us through a few slides so that the audience knows what we'll address. Here's a competitive advantage that Carl wanted to address. He talked about barriers. These are the barriers he would talk about. Carl wanted to talk about IP as an investment and what the benefits are from IP, and also what the costs of IP are, differentiating cost from investment. And then, guys, I know that we spent considerable time on due diligence, wanting to get to its importance and what the elements are. I don't think we're going to have time to come back to these. That's why I'm making the group aware that the slide set includes these topics. What I want to do is get to Joe Allen. I asked two key questions of Joe, and I'd now like to introduce his answers to those questions. Let me get the recording up, and here's the first question and the first answer.
Joe, as the author of the Bayh-Dole Act, please tell its significance for technology commercialization and the role of intellectual property in crafting it.
Thanks a lot, Bernie. It's a pleasure to join you and your audience today. It really goes back to the founding of the Republic. In fact, Abraham Lincoln said the patent system was one of the three greatest discoveries of humanity, and he also mentioned the printing press and the discovery of America, so you can see how highly Lincoln rated patenting. Lincoln also was an inventor, and he said that patents add the fuel of interest to the fires of genius. Before the Bayh-Dole Act, that fuel was missing from federally funded research, and we're talking about 50 or $60 billion of research a year funded through universities, small companies, and federal laboratories. And what happened was the government actually made the inventions made with government support were taken away from companies and universities who created it. These discoveries were then taken to Washington or taken to the agencies, and they were made freely available to all. But what happened was, without the incentives of the patent system, they really had little value. And these policies also drove small companies away from government contracting because they were rightly concerned that if they invented something, it would be taken, which it would have been. So what you had was this devil's brew of little coming out of billions of dollars of research, and also some of the most innovative companies in the country did not want to work with the federal government. I was on the Senate Judiciary Committee staff at that time, and it was an economic climate very much like today, where it looked like the economy was going downhill, it looked like America was losing its place in the world. And we started looking at this and found out there were 28,000 government patents, but they were just sitting on the shelf, not being used by anybody. And so Congress said, we can't simply stand by and watch billions of dollars of taxpayers' funding just go down the tubes. So a bipartisan partnership formed between my former boss, Senator Birch Bayh, who was a liberal Democrat, and Senator Robert Dole, who was a conservative Republican. And in the best tradition of Washington, they said, look, let's get together, let's work this thing out, and we just can't let this thing sit because it doesn't make any sense. The bottom line was we passed what's called the Bayh-Dole Act, and what it did was it injected the incentives of the patent system that Lincoln mentioned into federal research and development. Simply, it says that universities and small companies who make inventions now own the patent rights so they can be commercialized. It says that university inventors must get a share of the royalties, with the rest of the money being invested in more campus research. It also says that products that come out of this federal funding should be made in the U.S. whenever possible. Finally, Bayh-Dole says that the government can use the inventions they help fund, and that's mainly for doing additional research. So that's rarely a problem as far as companies trying to sell products back to the government. Bayh-Dole has not been a problem or a barrier for those companies. The upshot is that the Economist Technology Quarterly, which is a pretty prestigious magazine, said that Bayh-Dole is the most important law of the last 50 years because of what it did to help turn around the U.S. economy. We have about 7,000 startup companies being formed around patented university inventions. That's about 2 companies created every working day of the year. We're the only country in the world that has those kind of small high-tech companies being created, and particularly coming out of publicly funded research. University licensing has also contributed at least $187 billion to the U.S. gross domestic product in just 9 years, and created a minimum of 250,000 high-paying jobs. It's brought more than 5,000 new products to the market, And it's also been the source of at least 130 new drugs. So in addition to helping the economy, it's also really helping public health and welfare, not just here but around the world. It really has been a tremendous success. And in addition to these documented impacts, Bayh-Dole is also the foundation of the SBIR program. Bayh-Dole passed right before SBIR, and Bayh-Dole lays the groundwork that if you take a government contract, you will own inventions coming out of it, which again is the key to the SBIR program. Finally, President Reagan made Bayh-Dole the centerpiece of U.S. patent policies in an executive order, which is still in effect. So the intellectual property component is really the key, and what we've done is we've added the incentives of that the Founding Fathers intended of the patent system back into federally funded research where they really didn't exist before the Bayh-Dole Act passed.
There's another question that I put to Joe, and I'm going to bring his answer up now along with my preceding question. Just bear with me while I work to get the document out of my library.
When you were director for the Office of Technology Commercialization at the U.S. Department of Commerce, you helped to create the Federal Technology Transfer Act, which promotes transfer from the federal labs. How do these two laws, the Bayh-Dole Act and the Federal Technology Transfer Act, benefit small technology businesses?
As we were just discussing a minute ago, small companies are assured they'll own inventions made under federal contracts under the Bayh-Dole Act. The Bayh-Dole Act and the Federal Tech Transfer Act, and the Federal Tech Transfer Act is actually focused on federal laboratories. It allows them to perform cooperative research with companies, which means a company can put money, expertise, or resources into a federal laboratory, and the company is assured of having at least an exclusive license for what comes out of it. It also provides preferences. Both the Bayh-Dole Act and the Federal Tech Transfer Act provide preferences to small companies seeking patent licenses or partnerships from universities or federal laboratories. As we mentioned also in the last question, there's an additional preference given to those who will manufacture the product in the U.S. And typically, a university or federal laboratory is not just going to say, okay, who's going to pay us the most royalties? That's really not the focus of Bayh-Dole and the Federal Tech Transfer Act. They're really looking at who's the best partner for moving this technology to the market. And small companies have, by far and away, the best record of moving new technologies to the marketplace. So you really are in a situation with a small company where you can successfully compete with a Fortune 100 company, again, based on the preferences of Bayh-Dole, if in fact it looks like you really do have the wherewithal to bring a technology to the market. The other thing is, if you look at the expertise in our federal labs and universities, there's nothing in the world that really has the kind of resources we have right here in our backyard. You see entire industries like biotechnology springing from public sector research. When biotech first came out, the universities were actually looking to license large drug companies, but they weren't interested because of the risk and uncertainties involved in a new field. So what happened was the biotechnology industry grew from the formation of small high-tech companies, many of which spun out of universities, and they tend to clutter around university research. In fact, biotech, even today, 25 years after it was created, still remains centered around university research, and it's driven by small companies. In fact, the Biotech Industry Organization, which is the trade group of biotech, said that 70% of their companies are actually small companies. And most of these companies were actually formed from technologies that they actually acquired externally to the company. In other words, they got them from a university, a federal lab, or some other place. But at least half of our biotech companies right now have patent licenses from universities. So it's a great example of universities seeing an opportunity and small businesses having a partnership there, and it actually created a huge market. And many of these small companies like Genentech have grown on to become obviously big companies of themselves. What all this demonstrates is that opportunities exist, but it should be remembered that university and federal lab technologies are very early stage. So a company bringing them to market needs to really have a strong commercialization capability. This is not necessarily a simple process. It can be a high-risk process. It can be very expensive. But the fact remains there's tremendous opportunities out there, and again, small companies actually get the preference.
Joe, thank you. What a wonderful insight into the federal activity in support of technology development and commercialization. I think it's very clear the passion you've had for decades. You're the reason why good people go into government. For all of the complaining about elected folks, there are people behind the scenes who actually do the work, who are to be admired, and you're one of them. Thank you, Joe. The next slide is yours, Steve. Steve, I'm actually going to jump through here quickly. You're going to address protection, strategy, and portfolio, and not just the detail of a single IP. You're going to take a look at the decision between keeping something a trade secret and filing a patent. You're going to talk about the relationship of company assets to IP, and if we get a chance, you're going to address how to actually build value in the company. And I know close to your heart is the inventor threshold regarding patents, and then some common mistakes. Guys, we don't have enough time to get through all of this. I want the audience to know that I'm going to let us run over by 15 minutes. That's 20 minutes from now. We'll stop our talk, and then we'll open it to questions and answers. So, Steve, you've got it. You have to pick what you think is most important from here on. Have at it, buddy.
Okay, well, Bernie, that's a challenge because I have a hard time stopping. But on the next slide, let me just say this. There's a few basic concepts, and we're going to put some shoe leather on them, but the basic concepts that we're going to have in these following slides are this. One is that you need to look at a small business, really any business, needs to look at their IP asset portfolio as just that. It's a portfolio. Each one of those elements in that portfolio bring a certain different layer of protection or ability to address a market. And we need to get out of one-dimensional thinking and think multidimensionally when we're talking about building an IP asset base that really brings value to a company. And Bernie, you've highlighted, the portfolio part of that. And that's really what this slide is intended to uncover, to display. But one of the things I want to point out, Bernie, if you could highlight that improvements list there. We've got the things that go into the portfolio we've listed as innovation, improvements, processes, brands, and publications. One of the things that's often overlooked is the fact that as we move forward in time, inventions and the inventive concept are things that are living and ongoing. So the thing that we invent today, we improve tomorrow, and then we improve the next day, and then we improve, we improve the next day. What patents really are generally speaking, they cover incremental improvements in the state of an art. It's very unusual that we'll see a patent application filed that is some new technology that is so entirely novel that there's nothing like it in the history of the world. And because of that continuing improvement nature of the way that we develop products, it's important for the businesses to keep in mind that we're going to continue down a path, but we're going to spin off patent applications as we go forward. We're going to continue to improve the state of the art. That's important because when you go to license your technology, one of the questions you have to answer in that license is who's going to take ownership over the improvements? When you acquire technology through a license agreement, you're going to answer the same question. So we're going to talk about these things as we move forward.
Okay, I will bring you to the next slide.
Okay, this is an example of the kind of structured thinking that ought to go into developing an IP strategy. The question often gets asked, here I have this innovation. Now, should I keep it trade secret or should I seek patent protection on it? Keeping in mind that while a patent is very powerful and it's a monopoly, it's a limited monopoly. And under the U.S. Code, if I'm going to apply for a patent, I have to teach everybody else how to make and use that invention. That's actually a requirement in Title 35. So I'm going to teach my competition how to compete with me. However, in exchange for that, I get a limited monopoly. So we go through an algorithm here. We start off with the brainstorm. We have some innovation. We have an initial decision threshold. Can this innovation be copied? If I put it into the marketplace, is it copyable? I'm going to point out the example of one that has never been copied, and that's the formula for Coca-Cola. They've kept that trade secret, and because of that, they have maintained, that formula secret for about 100 years. In fact, I think over 100 years at this point. Had they applied for patent protection back at the turn of the century, and I'm talking about around 1900, what would have happened is they would have eventually lost the ability to control that market for the formula Coca-Cola, because after about 17 years it would have gone off patent. So threshold question, can it be copied? If the answer is yes, it can be copied, we better do something to protect it, because I'm going to put it out into the marketplace. There are a lot of smart people out there, a lot of smart people offshore, more now than ever. And the question we have to answer now is really, is it patentable? And there's two elements to that question. The first is it novel? Has it ever been done before? If the answer is no, it's not novel, well, now I've got something that I can't keep as a trade secret because it can be easily copied, and really it's not even novel. So that takes us down to the no protection block, and there's a business decision to be made now. Am I going to continue to invest in this innovation if I can't protect it? And that is absolutely a business call. It depends on the size of the market and your ability to address the market in other ways. For instance, just by sheer force of market presence. Large companies can maybe get away with that. Small companies have a difficult time with that. The small companies tend to rely more on protectable innovations that they can cover with patent protection. Some of the larger companies, for instance, in the old days, General Motors is a great example. Hard to compete with the big auto manufacturers because you just couldn't spool up a company and go out and compete with them bending sheet metal. Moving on to the next block, we come to the second question that we need to answer concerning patentability, and that is my innovation obvious? What a lot of folks don't realize is that even if an invention is novel, if the patent office determines that it's obvious in light of the prior art, it's not going to be patentable. That is a specific legal test, and we don't have time to go into it here. It's a very interesting aspect of seeking patent protection. The bottom line on that, though, is if we look at the prior art and we see that, well, gee, this invention probably is obvious using the legal test in light of the prior art, again, no protection. So we go back up that path. Maybe what we need to do is go back to the drawing board. Now that we know, after we've done our patent searching and we know what IP, what patents out there cover the landscape, maybe we need to drive our development away from the existing patented technology so that we ensure when we go back down through this decision path again, we've got something that can be protected. If the innovation is novel and not obvious, generally speaking, it's a good idea to apply for patent protection, assuming that it has commercial value and the other threshold decisions. This particular quick little algorithm is something that ought to be run through as quickly and as often as possible in the product development cycle, because every dollar you spend on an innovation that you cannot protect potentially is wasted investment. So Carl before talked about that's cost, but it's cost with no ROI, and that's not a good thing. This next matrix here, we're certainly not going to go through it. I just want to point out a couple of things. This looks just like Carl's matrix, only rather than address business issues and such things as tax treatment, this addresses the various legal issues associated with these particular types of IP assets. What I want to kind of point out here is if you look down at go down the asset list, some of the things that are often overlooked by small businesses are their internal know-how and their research data. This is the sort of thing we're going to keep trade secret. This is going to enable us to compete in a market to an advantage to us and a disadvantage over our competition. Databases, I'll mention this. In the new Web 2.0 world and beyond, if you look at most of the large web-based businesses out there, I'll just point out, for instance, Facebook. What's the value of Facebook? Certainly there's marketing, advertising, that sort of thing that they sell, but they are building very large databases, very complex databases with statistical correlations that cover really a worldwide population. That information is incredibly valuable, and you can believe and bet that they are keeping that information trade secret. And moving on down to innovations and processes, these are the kinds of things that we cover with either patents or trade secret protection. Again, I don't think we want to dwell on this chart. The point of this chart is for everybody to understand that each one of these particular pieces of intellectual property have different attributes, and they are protected in different ways. So when you get a chance, come back and look at this chart. Maybe we can have some questions about that after the presentation here.
Before you move on, Steve, I'd like for you to address the business part of this chart a little more. If you'd be kind enough to translate the assets of the company which are covered by some type of intellectual property, which provides the legal perspective, but extend that, if you would, to the 3 columns on the right, which touch more upon the business aspect.
Yeah, very good. Thanks, Bernie. When you look at the business aspect of this IP, and we look at the purpose for it and the type of ownership and the proof of ownership, there are a certain number of steps that need to be taken in order for these assets to actually be what I would call valued elements of your IP portfolio. And notice that each one of them is treated differently. It takes a business call and a business decision to segment your IP into these particular types of assets and put a policy into place that is going to actually protect these things in the end. So if you look over here, for instance, that third column, proof of ownership, if you'll notice, know-how, research and database, data and databases and proprietary information, protected by what? Protected by documents that we keep proprietary to the company, internal, obviously, to the company, but part of the company records. Why is that going to be important? Well, because later on, when we have to prove up ownership of a particular item, we're going to have to show 2 things. One, that we really did own it, and second, that we kept it secret. So if somebody steals a trade secret, or we enter into a non-compete agreement, or some other kind of contractual vehicle that is intended to keep somebody out of a market and allow us to participate in that market, we're going to have to go back and prove that we had that technology. That's an important business aspect of it. So,
Steve, excuse me, would you take one example here that people probably can best relate to, and that is innovation or a process for developing a product?
Sure.
And address purpose, etc.
Okay. Well, clearly, moving across the innovation line, let's just say that we're going to cover this with patent protection. One business aspect of this is that we're going to, as we apply for the patent and the patent issues, what happens is the patent office maintains a database of ownership. You can see, generally speaking, unless there's been an error, you can see who owns the patents that have issued from the USPTO. It's all in the database. Anybody can go up there and go online and look at it. So one of the things you're doing is providing notice to the world of your ownership of a particular asset. From a business perspective, that's very important, because one of the things that small businesses will do is you can use the USPTO database to go out and see who else is playing in your technology and in your particular market area. That can tell you who your competition is. It can also tell you who your potential teammates are. Notice of ownership is incredibly important from a business intelligence point of view.
Steve, I'd like...
Go ahead, Bernie.
Steve, what I'd like to add on the business side is that the cost shown on the balance sheet for a patent is the actual cost incurred, the legal costs, the filing costs, etc., all those costs associated with filing the patent, getting it reviewed, and issued. However, the value of that patent, when the time comes to negotiate a licensing right, the value of that patent is far more than that. There's the intrinsic value for revenue, particularly profit, that can be brought to the company over time in the form of profits or fees. The discounted cash flow of that stream of earnings to the present value is one of the methods for valuing a particular innovation that is represented by a patent. That's a particular business aspect I'd like to tie in here with your business look at intellectual property matters regarding legal issues. Steve, I'm going to ask you, Go ahead, make another comment, and then I'm going to move us to the next slide.
I just wanted to follow up with that. Basically what you're saying, Bernie, thanks for saying that, is that patents are a highly leveraged investment. Their value is potentially many times greater than the actual cost of acquiring a patent. That is why when you look at a company like IBM on the average files about 5,000 patent applications a year. What they're doing is playing the numbers game. Are all of those patent applications and patents going to be as valuable as one another? No. Some of those are going to be very narrowly construed. Some are going to be broad. Some are going to have a lot of market impact. Some are not. But the point is that in that huge portfolio that they're building, on average, a certain percentage of those patents are going to be very highly leveraged. And they know, based on the numbers, that is going to be a huge part of their company's asset portfolio going forward. So I just want to mention that.
Steve, when we get to the next webinar that deals with structuring a deal, the valuation of the intellectual property will be a central issue in the negotiations and structuring. I want to thank you and Carl for laying the groundwork to get to deal structuring in the next webinar. Let's move on to the next slide. Steve, you've got 4 minutes left. Have at it.
All right. Here's what I'm going to do. I'm just going to make a statement, and then we're going to burn through a couple slides. And the statement is this. Not all IP assets build value in the same way or on the same timeline. And let's just pick two of them. Patents. When they issue, they have a certain amount of value. You can enforce them instantly. So you have erected an instantaneous barrier to competition. Trademarks, on the other hand, do not have instantaneous value. It may be the most wonderful mark in the world, but the only way a trademark gains value is by the marketing and branding and advertising efforts of the owner. So you'll see trademarks grow in value over time. Patents may as well, but they acquire an instantaneous value, and this is why when we construct an IP strategy that is what we're going to use to address a particular market, we're going to talk just brief chart on that in a second. We're going to use these assets to build an aggregate value, taking advantage first of the patent's instantaneous value, and then later taking advantage of the trademark's accrued value. So we're going to do two things. We're going to apply for the patent, and then we're going to enter into a branding and marketing activity to build goodwill and to build value in the trademark. Both of those together are different layers of protection, and that's what this chart is intended to show. And in fact, a valid product development timeline strategy is to apply for patent protection, claim the patent pending status, go ahead and begin the marketing and branding activity, and you're doing all of this in parallel. The trademark has no instantaneous value, but the fact that we have pending patent applications gives us some value, and as those applications matriculate through the PTO, they tend to gain value until the day they issue, and then they go up in value again. And it may even be that by the time the patents come up to that point where they either issue or do not issue, even if they, in the end, are subject to a final rejection, just the fact that you have used that patent pending status to erect somewhat of a barrier to competition as you have built your brand name, it may be that your brand name can continue to carry you forward in the marketplace even if your patents don't issue or are narrowly construed. So that's why a layered approach to an IP strategy makes a lot of sense. Now, this particular chart we're looking at here is intended to, that's all it's intended to show, except I will add one thing. There's a very important concept. Bernie has circled it. And what I've called is the investor interest threshold. If you've ever wondered, if you've ever approached an investor group and had them not interested in you at all, what's happened is you have not crossed their interest threshold. And it's different for every kind of investor group there is out there, whether it's front-end investment or stage 2, stage 3. But the point is, investors typically want to see certain things, and it's actually important to sit down and create a strategy that gets you as soon as possible to the investor interest. This is a mistake that we see all the time when small businesses are putting together, their product development timeline. They're not focusing enough on building an asset base that captures investor interest. And it's hard to proceed forward without any investor interest these days, given the cost of bringing a product to market. So,
Steve,
this
I'd
chart
like
just
to
is intended to show that concept.
I'd like to have the audience connect what you just said about patent interest, the threshold, with the very first webinar, which addressed the technical development cycle and the various phases along that cycle for technology, discovery and development, product design, and product manufacturing. They represent different stages of development, and to proceed forward along the development cycle is to add value to the technology and the process of bringing the reality of a new product from that technology. I believe there is a parallel here, and maybe at another time we could address your patent pending investor interest threshold along with the stage of development of the product. I'll move us to the next slide. Steve, we're actually done. It's 11:16. I'm going to give you a minute to say something about each of these slides.
Two more slides coming up. One is common patent mistakes. The other is common trademark mistakes. And here's the message. This is a very fact-intensive practice, and there are certain things that can be done that can negate the value of a piece of IP, and you have to understand what those are if you're going to put together a valid business plan. Just as an example, up at the top, we see violation of that particular piece of the U.S. code. It's important to understand there are federal statutes out there that say that if you offer your invention for sale or use it publicly or describe it in a printed publication or on a website in this country, you get 12 months grace period to apply for a patent on that particular invention. If you don't, you are forever barred from getting a patent. But even more importantly, in other jurisdictions, for instance in the European Union, you may get 0 time. So the best advice is don't offer it for sale, don't use it publicly, and don't describe it in a printed publication. In fact, get everybody under a non-disclosure agreement. Before you don't do any of those things before you file your patent application. That's just one example. There's a number of other mistakes that are made when it comes to patents. Bernie, if you want to kind of move on to the other slide as far as common trademark mistakes. I'll just point out one of the things that we see happen quite often in trademarks is we have inconsistent use of the mark where the mark is used in various instantiations over time. That actually dilutes the value of the mark. So what we take from these slides is there are some important ways of proceeding forward. They're very simple. They just have to be understood, and these are just some of the common mistakes that we see.
I'm sorry, but we do not have the time to address the challenges that business folks have regarding intellectual property in their businesses and the protection tips. But there is a slide here which addresses that topic. We have worked to meet the objective that we set for this webinar, which is to identify and define the several different types of intellectual property and explain the differences among them, and to help lead folks to recognition that IP happens to be a tools for creating a strategy in protecting technology and products and company image. The significance for this particular topic is to secure intellectual property, add value to the technology in the company, help the company grow through utilizing intellectual property as a tool to create products and sell those products. Carl, I was going to give you a chance to tell folks about the next webinar, which is the anatomy of deal structuring. We don't have time to do that. I'll just say it's the process of addressing all the issues that must go into licensing or selling intellectual property or putting a co-development deal together or a joint venture deal together. And some of you heard Wayne Pitcher talk about the joint venture for Genentech Core, the joint venture between Ciba-Geigy and Genentech. I want to, on behalf of Chester Straub and TRDA, thank everyone for attendance at this webinar. We truly hope that you benefited from it and can take a pearl or two home and bring it to your company operations. I personally thank you, Carl, and Steve and Joe. I want to thank all three of you for the content and the delivery. And I'm going to open this to questions and answers, and we've been recording them. Thank you. Thank you, Diane. The first question comes from Lee Wayburn. Lee wants to know, can we get an example of a contract IP? Lee, if you're asking for a sample contract, let me tell you that Carl Dakin in the next webinar is going to address the articles that go into the contract, because those articles represent the structure of the deal. Tim Hamilton asks, would either Steve or Carl like to add to that?
Yeah, I will on that, Bernie. An example of a contract IP would be where you have a piece of information that does not rise to the level of being a trade secret or may not potentially grow into a patentable item, and you enter into the agreement and you say this will be treated as confidential information and shall not be disclosed. And by entering into those terms and conditions, you have created a higher level of protection for that particular information than you would find under trade secret or other law.
Thanks, Carl. Tim Hamilton gives us the next question. Tim wants to know, would a company logo or name fall under the image asset category?
Bernie, I would say not generally. You know, a company logo or name is typically a trademark issue. I think maybe when Tim is asking the question, he's really thinking about, when we put image up there, we had talked about that in the context of a copyright. And specifically, a trademark or a logo is intended to identify a particular business or provider of a particular good or service, and that is the domain of trademarks. So generally speaking, we don't seek copyright protection on logos, for instance.
Loretta Kish asks the next question. Loretta asks, is information shared under an NDA a trade secret?
Carl, did you want to answer?
Yeah, I'll go ahead and take that. An NDA stands for a non-disclosure agreement, and it is an example where under contract law you may achieve a higher level of protection for information that does not meet the statutory definition of a trade secret. So the information may very well be a trade secret and meet that threshold, but it also could include information that doesn't meet the threshold. So without getting into the specific example, the information and the definition of the state law for trade secret, it's impossible to say, but the creation of a non-disclosure agreement gives you a wraparound that's potentially larger and greater than a trade secret law.
Carl, if I could just add to that
Go ahead,
quickly.
Steve.
An NDA can be an incredibly powerful agreement, not only for the reason that you just mentioned, Carl, but Loretta, to take your question one step further, normally what we would do is also add non-compete language into that agreement, so that we're going to get an agreement that whatever information you're providing certainly is going to be confidential. It might even be trade secret if it rises to that level. We're going to get them to agree to that and also to not compete with you with your own data.
Next question comes from Callie Smith. Callie believes that this question has been answered. Steve, you have answered it in large part, but I'd like you to get to another part of the answer, and I'll tell you what it is after I read the question. Can you refile a patent once it's expired? Or does it need to have new technology and need to patent that only? I'd like for you to address improvements. I'd like for you to address continuation in part. I'd like for you to address new technology that's wrapped around an old technology, such as a chemical delivery system wrapped around an old off-patent molecule.
Very good.
It's yours.
I'll go ahead and jump in. First of all, just to answer the question, no, you can't refile a patent that has expired. Once it's expired, it's expired. And for the purposes of the claims in that patent, whatever's covered by those claims is out there now for the public to use. But Bernie has mentioned improvements, and this is in fact something that should be done with I guess prior planning and thinking, and that's part of this product development cycle that we're talking about. You're always looking for and striving for reasons to file new patent applications, or Bernie mentioned continuing or CIP applications, which are a particular type of continuing application where you add new matter to an application that's pending at the PTO. And it's those improvements that you can get patent protection on going forward. So what happens is you file your base patent, you improve the technology, you continue to innovate, you file a new continuing patent application if the old one is still pending, or if it's issued, you file just a new patent application. But to answer your question, you are continually covering the improvements on the state-of-the-art. These are incremental improvements on your old invention, and what you're hoping is that those improvements are going to have enough market value that inventions, products that come out to compete with your new improved invention, using your expired patent are simply not going to be good enough. Why? Because you've improved the invention. And so you're seeking patent protection on that as you go forward. There are people out there who will take old technology, as Bernie mentioned, and wrap new technology around it and file for patent protection on the combination of the two. Bernie, I think that's what you were talking about.
Steve, could you clarify the distinction on a provisional patent and its expiration?
Yeah, I'll do that, because a provisional patent, there is actually no such thing as a provisional patent. There's a provisional patent application. And all that really does is buys you time. It buys you 12 months to file a regular application. The reason you file a provisional is to get a quick filing into the patent office for whatever reason, either for cost and expense reasons, or maybe you're trying to beat a deadline. But in any event, a provisional patent does not result in an issued, a provisional patent application does not result in an issued patent. That's a common misconception. You get 12 months from the day you file a provisional application to come back and file, based on that provisional, file a full-blown U.S. utility application. And let me just mention one other thing. The common mistake in provisional applications is they are too quickly drafted often, and they do not completely disclose the invention. And that's maybe subject for another webinar in the future.
Guys, I'd like to move to another question. Kelly, I hope you got sufficient answer to your question. Brett Bouchine asks one or two questions here. The first is, what are the procedures for documenting and protecting trade secret property?
Carl, you want to? We can.
Yeah, I'll take this one.
Sure.
With regard to a trade secret, the first thing you would do is you'd want to create a narrative or written description of what is the trade secret, what is the element of value that attributes to your company because it's held in secrecy, you have the right to use it, and meeting the criteria of the statute. And then you want to get into all the documents that show how you created that trade secret, the cost, the time, who was involved, any communications involving the trade secret. Because as Steve pointed out earlier, the biggest problem is walking into court saying you have a trade secret and then being unable to prove that you held that information in secrecy because you left out copies of it on the receptionist desk, or you shared it at a meeting at a scientific conference, and it's technically no longer a secret, and therefore you're not meeting the statute. So the records in trade secrets largely have to do with showing that you did check it in and out of a library. It was stamped confidential, knowing who saw it and who didn't see it, to show that you maintained the secrecy.
Gentlemen, what would be the difference between these procedures you just mentioned for documenting the existence of a trade secret versus the records that are kept in a due diligence book. Once a discovery is made, that due diligence book begins for the date of conception, and then a record is kept of all of the conversations, the people who are met, as well as the research work and the development work that's done on that discovery. What's the difference between the two?
I would consider them largely the same. The due diligence is the process of examining these records to determine that they're complete and that you have done all the necessary steps to protect and maintain your IP. And it's, to me, the largest problem is there's a tendency of the business to wait and try to create the records later rather than create them contemporaneously with when the innovation is occurring, when the costs are being incurred, when the communications are taking place. Records created as you do them are much better and will stand up better in court than trying to figure out later out of your memory.
Yeah. An add-on question, which is, Steve, I'm sorry, I want to ask this add-on question. What happens if you see your trade secret in the market? One, that someone stole it, and two, that someone else simply stumbled upon it. Does the person have recourse if someone just stumbled upon it? Let's take that last part off. Let's just address both. One is stolen, and one is stumbled across.
Carl may have a different answer here, but my answer would be: if it's stolen, you obviously have recourse. If it's somebody just stumbled upon it, though, if it was that's called independent development, independent creation, you're not going to have any recourse. So, in fact, one of the definitions of a trade secret is that it's not out there available. In other words, you can't. I'm the one who holds it; nobody else has it. That's as opposed to confidential information, which we talked about being covered, for instance, by a contract. So, if somebody stole it, though, you definitely have recourse. What's going to be called into question, as Carl has mentioned, is what steps did you take to protect it?
Gentlemen, I want to ask the next question here. Thank you. Let's see. This question comes from Factory Supply Inc. How do you enforce an NDA for an internet sales-based website?
Sorry, I don't understand the question, Bernie, because an NDA would be, I'm going to have to fill in the blanks and assume that somebody came up with a domain name they think is cool and is marketed, has some value in the market, and you're talking about selling it before you've registered it, where it would already be in the public domain. In that case, an NDA would be simply a statement that I have a possible name, I haven't filed it yet, I want you to keep it in secrecy while we discuss the potential sale. If you don't sell it, then you still have to keep it in secret for a period of time after our discussions or negotiations are over.
Carl, I would tend to take a different view of that. It may be that somebody has a web-based application that they want to have developed, and during the development cycle, they're trying to keep it secret so they can, hit the market with it running, and somebody else doesn't jump in there and beat them to market with their own product. We have a number of clients in that vein here at the firm, and I guess what I would say is you would enforce, if that were the case, you would enforce that non-disclosure agreement the same way you would enforce a contract. And that is, you would basically bring a breach of contract claim in the appropriate court, whatever jurisdiction would apply in that case, depending on where the parties live and so forth. Once it's out in the public domain, then it's no longer subject to the non-disclosure, right? Because the act of disclosing it may be a breach of a contract. Once it's out in the public domain, though, now people are going to take it and run with it, and it's no longer a trade secret. So that's if that's the nature of the question.
Gentlemen, I want to move on to the next question. This comes from Lavi Goswami. Does one need to register a trademark before using a trademark outside in the market?
That's an easy question. a trademark will not issue unless it's being used. If it's a federal trademark, so we're talking about interstate commerce, you should seek registration. You should apply for registration before you use it, in my opinion. That's a particular kind of application called an ITU, or an intent to use application. And the reason for that is you will get a preliminary, really not a preliminary, you'll get a trademark search done by the Patent and Trademark Office, and you'll get the results of that. It will not issue, though, until you are actually engaged in commerce. You're going to have to actually provide proof of that to the Trademark Office.
Gentlemen, this will be the last question. This comes from Louis Gavantis. Louis wants to know, would like for us to address the global impact of piracy and enforcement versus lost capital.
Well, my response to that would be that from a business perspective, you have to assume that there is going to be piracy of your intellectual property rights, and the location of where the piracy takes place may create a situation where you have no legal recourse. There's really nothing that you can do to stop or end the piracy. If that pirated product or good is brought back into a country where there is intellectual property rights, you may be able to block it at the border and have it seized and confiscated as contraband. But there are large segments of the world where there are no rules, there is no protection, and that's the way you have to do your business.
Gentlemen, I want to thank the audience again. Thanks for very good questions, for the attention, and I hope, like I said before, we've given you enough pearls to take home and use. I want to again thank Steve and Carl. The presentation, the content, the answers to the questions have been wonderful. I would let now each of you say your final words, your comments as you like, and then we'll call it a webinar.
Well, I would like to thank the audience for participating, and I invite everyone to come to the next webinar where we're going to talk about transactions. But the one point I'd like to leave with everybody is that the IP needs to be managed. You have to incorporate it into the strategy, the business plan. You have to understand when and why you're spending your money and the outcomes and benefits that are going to come from that. And that has to be done continuously throughout the life of your business. It's not something that you can put off to another day.
Thank you, Carl. Steve?
Yeah, Carl, just building on that, I completely agree. Bernie, again, thank you for allowing us the opportunity to address these questions, and I really appreciate everybody. I'm not sure how many people we have on the webinar today, but I certainly appreciate you dialing in. Bernie, I will say this. The work that you're doing over there at the TRDA to bring all of these issues to light, as we've worked together on your commercialization assistance program, and aiding these the high-tech companies, startups, some of them pursuing SBIR money and kind of living on that, making the transition to a viable commercial enterprise. These tools you're providing are really valuable. I hope that you're able to continue the series.
Thank you very much personally, Steve. That's very kind of you, and I think all of us are in a community that's very special, an entrepreneurial community, small business entrepreneurial community. A technology-based community is very different than the general business community. I think we all appreciate each other for the care and the giving that we provide. Thanks to everyone. Again, this is a webinar. Next webinar is October. See you then.